State of Orissa vs. Sharat Chandra Sahu. A legal analysis of sections 494 and 498A of the Indian Penal Code. Sharat Chandra Sahu is the husband of the complainant. The complainant wife filed a written complaint to the Women's Commission, alleging that Sharat had contracted a second marriage during the pendency of their marriage and that this act constitutes bigamy under section 494 of the Indian Penal Code. She alleged that Sharat demanded money from her after marriage. These demands caused harassment, which is an offence under section 498A of IPC. And she sought punishment under sections 494 and 498A of IPC. The Women's Commission forwarded the complaint to the police, and case number 418/1993 was registered. The police investigated and filed a charge sheet. The SDJM of Anandpur framed charges under sections 498A and 494 of IPC. Sharat filed a petition under section 482 of the CRPC in the Orissa High Court to quash the charges.
The High Court partly allowed the petition. The charge under section 494 of IPC was quashed as the complaint was not filed personally by the wife as provided under section 198 of CRPC. The charge under section 498A of IPC was retained.
The Supreme Court held that the High Court wrongly quashed the charge under section 494 of the Indian Penal Code. Section 494 of IPC criminalized bigamy and is a non-cognizable, bailable offence, and it requires a complaint before a magistrate. According to section 198 of the Code of Criminal Procedure, the complaint under section 494 IPC must be made by the aggrieved person or relatives. The High Court held that the complaint under section 494 of the Indian Penal Code was invalid as the wife did not file the complaint as the complaint was filed by the National Commission for Women. The High Court overlooked the fact that section 498A of the Indian Penal Code is a cognizable offence. Under section 155(4) of the Code of Criminal Procedure, if a case involves both cognizable and non-cognizable offences, it is to be treated as a cognizable case. Therefore, the police can investigate the entire matter without prior permission from a magistrate. When a cognizable offence like section 498 of the Indian Penal Code is involved, the police may investigate all related offences in the case. This authority extends to non-cognizable offences such as section 494 of the Indian Penal Code. If prima facie evidence is found, the police may file a charge sheet for all the offences involved. Section 155(4) of the Code of Criminal Procedure was introduced in the 1973 Code of Criminal Procedure. Its purpose is to remove procedural uncertainty when cases involve both cognizable and non-cognizable offences. It ensures that police investigations are conducted as a single, unified process rather than being fragmented. The presence of section 498A of the Indian Penal Code empowered police to investigate. The police could therefore file a charge sheet for both offences, including section 494 and 498A of the Indian Penal Code. Consequently, the High Court's decision to quash the charge under section 494 IPC was legally unsustainable.
The case exemplifies proper handling of cognizable versus non-cognizable offences in criminal law. Thanks for watching.